Good afternoon, everyone. Welcome to our latest podcast episode here at AmLaw Group, where we love talking about all things related to business immigration. And here, as always, is my close associate and partner, Alexander Verbitsky. Alex, thanks for joining us again.
Thanks for having me.
Absolutely. So we kind of jumped on this because Alex and I were having kind of a brainstorming session about some potential client cases. And we thought, hey, we really need to make a podcast episode about this because it's interesting topic about E2, somewhat complicated. I'm sure all of you can understand it, at least hopefully with our explanations. But I think it's actually quite relevant and increasingly something that comes up with conversations that Alex has been having with a lot of new potential clients. Right, Alex?
Yeah. Yeah, it's very interesting and to have these conversations and then be able to put it into a podcast form so that we could share it with them and for anyone that's listening that is in a similar situation, to learn a little bit
Help
from
them
it.
out
Yeah.
as well, yeah. So
Yeah.
here's the question, I guess I kind of passed it over to you without making the intro. What exactly are we talking about that's so interesting here? So what we're talking about in general, and we'll kind of go into some case studies, is the various scenarios that are possible with an E2 where you have investors and employees and various combinations of that. So people often ask, hey, let's say there's an owner of a US company and he's Canadian or Turkish or whatever, right? Is his essential employees get the E2? Or can it go vice versa? And if you've got essential employees, can you change your status in the US or can you not? Or what limitations are there? So today's episode, we're going to talk about all these different kind of combinations where you've got, obviously, you always have to have an investor for an E2. That's a given. But then, investor does an E2 or doesn't do an E2. How does that affect the essential employees and how do we do all that? So, Alex, maybe we'll start with some of the scenarios or case studies or questions that you've had recently and build the dialogue on that.
Yeah, for sure. So let me just paint a picture for our listeners to what we're going to be answering and going through because it is intricate. It is interesting. And there's obviously a bunch of different possibilities with this specific scenario. So I actually had a call with an individual from Turkey. And this individual, let's call them the essential employee of the company. His boss opened a company in the United States and wants to send his essential employee to the United States. Now, or the main question is, can this essential employee get an essential employee E2 visa in the United States without his boss needing to be a E2 investor visa holder,
Uh-huh.
right? Or does the boss need to have the E2 investor visa and then the essential employee, we could submit that application for them as well, right? So what is the timing and all that in that scenario?
Right. So it's an interesting scenario, and I'll have to admit we've been doing this a long time, and for some years we even had the wrong impression that we always kind of thought that the E2 investor owner had to have the E2 visa in order for the essential employee to receive his or her visa as an employee. But after years of experience and other interactions and stuff like that, the answer is it depends, right? It depends. So if the investor, the owner of the US company, is in the US in some other status, like long term, we're not talking you're coming for a couple of weeks for vacation or something. Like maybe the owner has an F1 student visa, or maybe the owner has an L1 visa, I don't know, or maybe an H1B, they're working here in the US and they also own that company. But so if the owner of the E2 company that we're talking about in US is resident in the US, then yes, that person needs to have an E2 status in order for any employees to get invited and come over as E2 visa holders as well. But if that owner is not resident in the US, right? It's he or she just owns the company in the US, operating it from Turkey or wherever, then in that case, you don't need it's not required for the investor or the owner to get the E2 first prior to the employees. So that's a very kind of interesting intricacy, if you want to call it that, with the
Yeah.
equal situation.
So in this particular situation, the investor, the person that owns the US company, let's say they don't want to move to the United States,
Right.
not their intention. They want to remain in Turkey, but they
Mhm.
want to send an essential employee. So it's definitely possible. Now, to further the scenario, that essential employee needs to get a status as soon as possible. So do they have to go through some sort of consular process, or can they change their status in the United States for an E2 employee visa?
Right. So with Turkey, so assuming then the essential employee is a Turkish citizen, the wait times are pretty long at the consulate and the embassy in Turkey from our experience. Pretty long, meaning, I think 6 to 9 months wait time, unless you get really lucky or something. So if this employee wants to get over to the US ASAP, then their fastest route to doing that is probably coming to the US on a tourist visa. So they have to have, a B1, B2 in their Turkish passport. It has to be a Turkish passport. So if they have a second passport, they can't use that second passport if they want to use the Turkish citizenship for the E-2. And so it's probably faster if they come to the US and we change status here. And we can certainly do that. But again, I'll remind everybody out there, you probably know, but if you're changing status in the US, you're not getting a visa. You're just getting status. So what that means is you've gotten permission from the immigration service to live here, and they generally issue status for up to 2 years at a time for E-2s. But the moment you leave the US, like if you want to go back to Turkey in 6 months or something, that status is canceled, done, it's gone. And in order for you to come back on an E-2, you've got to sign up at the embassy for an E-2 interview, go through that, et cetera.
Okay, perfect. Now let's further the scenario.
Uh-huh.
Okay,
Am I
the
doing well so
the
far? Am I doing okay so far, Alex?
yeah, yeah,
This is
it's
like
really
progressively
good.
harder and harder. Right.
Yeah, yeah. It's just adding on to the scenario because of course that E2 essential employee is going to want to visit family and they
Right.
don't want to be landlocked, right? As you said, right? Like you only get status, you didn't get a visa, right? So now my question is, we can help them get that E2 status. So they come down, the investor has made the necessary investments into this US company, they've spent it, they've purchased assets, business is operating, E2 essential employee, we submit their application, they get change of status, right? They can just really quickly, they can do a premium processing time for E2 employees, is that correct? Perfect.
15
So they
days.
go through that process. Let's say once we submit the application, if they pay for the premium processing, 15 days, they'll get an approved change of status, correct?
Correct.
Okay. Now, once they get the change of status, can we work on submitting a consular process for them while they're in the US? So that, especially for this Turkish, because like, I mean, 8 to 9 months is a very long time to wait,
Mhm.
right? So they're
Right.
obviously not going to choose the consular route because it's just too lengthy. So their only option is if they want to hit the ground running, they have to do the change of status in the United States. And then can we submit the consular route for them?
You can, and that's a good idea, right? So, like saying, okay, so that the client's not going to be landlocked for 2 years. At least once he changes his status, we quick do the paperwork and file it at the embassy, knowing it might take 6 to 8 months. He can sit tight in the U.S. for that period of time, but he knows, let's say, in the next year he's got to travel. That's a good idea. We can do it. Here's the potential downside, and I'm just speculating because it's really on a case by case basis, and it really depends on the consulate too. And to say whether how they would react to this in Turkey, I can't say for sure. Maybe we haven't had a whole lot of experience there, but the consular officers don't like it a lot when they see people changing status in the US and then shortly after that coming to the embassy and getting the visa because they kind of see it almost like as I don't wanna say gaming the system, but they
Mm,
see it as, "Well, why didn't you come to the embassy to start with, right? Why did you go to the US? Oh, you went to the US because you wanted to avoid the line here at the embassy," or something like that, which I don't think there's anything wrong with it. I mean, look, yeah, the guy
yeah.
can't wait 9 months, the business is ongoing, they need to get to the US. But I just have to throw that out there that sometimes that can be, a negative factor in the eyes of the consular officers. Would that necessarily be the case here? I can't say. I would hope not. I can't remember where we've had a serious problem. Maybe 8 years ago, 10 years ago, we had a couple times where it came up where the officer saw that the applicant changed status in the US and then went to the US went back to the consulate to their home country and then got the visa. And again, even in those rare cases where the problems come up, it's hard to say how much this was the issue that caused the problems or maybe there was some other issue in that person's past that caused the issue. Like, for example, I'm remembering one client from, an Eastern European country. He had a problem, but we later found out that his dad or his uncle was a high official in some of the security services there, stuff like that. So you never know what's going on behind the scenes. So anyway, this is just a way of saying that don't just assume because you're able to change your status in the U.S. that it's going to be super smooth sailing. There's not going to be a problem at the embassy. I mean, usually there is not a
Okay.
problem. And again, it kind of depends on the business too. And I think you mentioned a little bit, Alex, about this business that they, in this particular case, they're manufacturing equipment that's used at airports and stuff like that. That I would say sounds like a real serious business, and I think there would not be a problem at the consulate, right? But let's say
Yeah.
you're running a small fast food stand or something like that, and they're thinking, oh, you're kind of you're trying to sneak around the embassy, get around the lines, going to the US and changing status, they might be more skeptical. But this where, if the vendors or the partners of the Turkish business are, US airports or airlines and they're buying this equipment, that's a really strong story, I would say, that there
Right.
should be problems.
Right. So, just to clarify, this applies to E2 employees and E2 investors, right? Like this whole, it has to sort of pass the smell test, but also the risk
Yeah,
factor
yes,
of
correct.
everything,
Yeah,
right?
yeah,
Yeah.
yeah,
Okay.
yeah, correct, correct. But I think
Okay.
I would say I would say though in the employee scenario, the risk is lower because the employee can say, "Look, it's not my problem. My boss said I got to get to the US to start working and we're launching these operations there. What did I do wrong?" Whereas with the investor, he or she's putting the money up, they're more in control of the operations, right? So I think with the
Yeah.
employee, you're more protected. Definitely.
And just to add, right, like you mentioned, it depends, right? You said in this scenario, because they are a larger company, it's sort of going to be viewed as, okay, we understand you have to come here really quickly, you have to change
Mhm.
the status. The wait times are very long in Turkey, so therefore, it's okay, right? But in, let's say, the listeners here that are
Have more of a
smaller,
family
okay,
business, small business,
yeah,
yeah.
family business, mom and pop shop, right? It's sort of like a grain of salt scenario. We probably have to have a consultation just to make sure that the
Yeah,
best
yeah,
path
there's a lot
forward.
of facts that kinda go into this, and it's hard to give them all right over, and during a podcast or something immediately. Like, sometimes, for example, what could play against the interests of the investor? Like, say it was the investor, he came to the US, changed his status, but let's say that investor had a visa denial not too long before, let's say for a tourist visa. Well, that doesn't make sense because how he got here. Or let's say his spouse had a tourist visa denial, right? So he still had his tourist visa. He came here alone right after that. Like when they see these kind of, I don't want to say games, but they see these questionable things in your back, in your history, and they're thinking, what's kind of going on here? So it's really on a case by case situation. We'd have to look at it.
Yeah, so we're definitely going to need to have a consultation with anyone interested in that are in this. I wouldn't say predicament, but this is a scenario we have to explore. And obviously, during a consultation, you have to lay all the cards on the table because we have to be able to consult you properly so that there's no hiccups later on, right? Obviously, as the immigration law firm, we're limited based off the information that you provide us and the actions that you are, let's say, about to do or going to do in the future, right? So if you do anything that would affect the existing application while it's being filed, please let us know so that we could advise you, yes, you can do that, and or no, you cannot do that,
Right.
because we've run into those scenarios in the past before.
Yep. Absolutely. Absolutely. Yep. Full transparency is necessary. Full
Yeah,
complete transparency.
exactly. So I think my follow-up question is very interesting because they're both Turkish nationals as well. Separate, example, but really interesting. In the last week, we've had, similar, very, very interesting possible cases and possible clients that we will have. And these ones are interesting. I won't get into too much detail, but essentially they're going to be 50-50 partners of a business in the United States. Now, we know that with a 50-50% partnership, if both are seeking the E2 investor visa,
Uh-huh.
each respective party 100,000 US dollars.
Uh-huh.
In this scenario, what I advise them to do is that, yes, you can go into the business 50-50, but have one of them be the E2 investor and the other be the E2 employee, right? So we're figuring out between them which one is going to be the investor and which one is going to be the employee, right?
Mhm.
Obviously, we did answer the question of changing of status within the United States because this is something that they're going through, is that she needs to be in the United States as soon as possible, right? Now, the business partner has a residency in two other countries. And my question is, well, it has to do with the interview aspect to it, right? If this business partner is going to be the main investor, that means the E2 employee visa, and we could submit the E2 investor visa later on for this individual, right, that is not in the United States. I hope I'm not being too confusing, right? It's a
Right.
little complicated. This E2 investor, number one, doesn't speak English very well. So the question is, can a translator be used during the interview process? And number two, can the interviews be done in countries outside of the nationality of the E2 investor, which is, in this particular case, Turkey,
Turkey,
right?
right. So let me answer those questions first too. So regarding the use of translators, and this comes up quite frequently, usually when this exact scenario where they'd like to have an interview outside the home country or the country where they have citizenship because they might be residing somewhere else and they don't speak the native language in that other country. So the general rule right now, since there was a policy change last year, is you need to have any interview in your country of citizenship or nationality, right? So in this case, theoretically, they got to go to Turkey. Now, if one or both of the investors has residency in another country, then if you have some kind of residency permit, whether it's temporary for a couple of years or permanent or whatever, so it's some kind of status that you have in another country besides just as a tourist or as a student, then you are allowed to go to the U.S. consulate if there is a consulate or embassy in that country, and they do process E-2 visas. You can go there for the interview. So yes, if this person has official residency in some other country, then in theory, yes, they should be able to sign up for an E-2 interview in that country, assuming they process E-2 visas in that country. Not every country does. That's the first thing. As far as interpreters go, let's say that person is in, UAE, in the Emirates, in Dubai or something, and the person doesn't speak Arabic and they don't speak English too well, but they speak Turkish. Whether you can take a translator just depends on the embassy. Each embassy is really different. You gotta contact them in advance and find out. Some have no problems, some refuse to allow them, and some are kind of in between.
Okay.
So this is
So
an interesting
so
thing too. Now, the scenario you brought up, if I don't know if you asked this question, but I'll maybe throw this out there. So we had a scenario where there's two 50-50 owners. And I don't know if we've ever had this situation, I'll be totally honest. Let's say where one of the 50% owners, so let's say there's owner A and B. Owner A is not in the US and doesn't want to get the E-2 visa right now. Okay, fine. Like we just discussed, owner B, as an essential employee, could get the essential employee visa because owner A, isn't residing in the US, and that shouldn't be a problem. But here's a question. I mean, if owner B is an essential employee and also owns 50% of the company, I don't know how the embassy is going to look at that. Are they going to say, oh, you're a 50% owner, but you just want to come over as an employee and you don't want to, have to prove how much money you invested, how did you acquire your 50% share? That's a good question. I don't know the answer right now. We're gonna have to do some research within the team, discuss all that, because if you're such a substantial owner that you have 50%, right? You have a veto right to block the other person. I mean, I'm not saying it's a high likelihood that they would challenge it because generally the embassies don't challenge business structures that entrepreneurs set up. So for whatever reason, hey, they want to motivate this key employee and they said, here, we'll give you 50% of the business. The government, the embassy is not going to get into that business decision and say, hey, why would you give somebody 50% of your company? You should have only given them 10%, stuff like that. So they're generally not going to challenge those financial structures or business structures that you have. But at some point, if for some reason, and we might need to know some more details about this particular scenario, but if it looks like that this person is really a 50% investor, but in order to not invest 100,000, right, they're qualifying him as a employee, and and it could be an issue. I'm just
okay.
flagging that. But it's
Okay.
an interesting scenario. Yeah.
Yeah, very. I mean, another, let's say, way to, well, the example that you provided has to do with the fact that potentially that the investor B or E2 holder B,
Mhm.
50% owner B, did not, you're giving the scenario that they did not invest but own 50% of the business, right?
Right. Right.
So this could be like an equity game where, one individual invests and the other individual is providing, let's say, sweat equity or whatever,
Right.
and
Right.
some
Right.
sort of split, whatever they have. So I just want to revert back to this scenario because the one that I previously gave about the 50-50 owners, would you advise that it would be better to have the individual that is coming into the States who was initially seeking, or I advised the E2 employee visa, that they actually do the investor visa just to like eliminate risks? Because the other 50% partner, he doesn't care. They don't care to be in the United States, right?
Yeah.
We can get them the E2 employee visa later on, and then they could travel freely into the United States. But on the operations side, they don't they're not really involved.
Well, yeah, so that's well, there you just made a very important comment. You said if on the operation side they're not really involved, that might create some limitations, right? So theoretically, if you're a E2 an investor, you don't have to be involved in the day-to-day operations, like going to the office or going to the restaurant and cooking the dinner or whatever, the meals for the food for the but you've got to be directing at a top level, you need to be kind of involved with operations. And so if this owner A that we're talking about who's staying overseas and that person isn't going to do anything with the business really, maybe they just put the money in and they're going to forget about it. That might create some limitations on how much, whether that person could be deemed an essential employee or even investor or something. So to get back to your question too, like would we advise owner B to come to the US and maybe change status as an investor or as an essential employee? We'd have to get more facts, I think, about what his or her role
Yeah.
would be. Like, what would their role be at the company? There technically, theoretically, maybe is more risk of showing that this person is essential, depending on what their role is. If we look at it and say, yeah, there's no problem, we can easily show this person is essential. But if we think they might not, they might challenge that this person is an essential employee. In that case, we might say better to go the investor route, right?
Okay.
So I think a lot depends on kind of the nuances and the details, and that's how we'd advise.
So just lastly, just to sort of provide just one last question and scenario for this particular situation, does ownership structure, because you mentioned the 50-50, you guys are just sort of like the E2 employee that's coming to the United States, there might be a question of, you guys are just sort of going around the idea that you have to make the investment. So is it possible that there could just be a 60-40 split, whereas the 60% owner is overseas, the 40% owner is the E2 employee visa holder, and then once the visa is issued for the E2 employee, they could just sell, let's say the overseas owner sells, shares to the E2 employee visa holder. Is that possible?
Yeah, I was thinking about that too. I was going to propose that. I mean, you could split it 60-40 and then make it 50-50 later. I'd probably even do it a larger split, maybe,
Okay.
90-10 or 80-20, just to reduce the likelihood of any questions. If you have an essential employee and they got 10% of the company, okay, that sounds pretty reasonable. And then just after that person acquires a visa, you can restructure it however you want. Provided that, and I think that's what you're proposing, provided that that owner A never has less than 50, right? Because then there could
Yep.
be some problems or something. But yeah, yeah. So
Amazing.
I guess what this shows is there's flexibility here with the E2. You can set it up different ways. And if there is a situation where it's like, hey, we don't need 200,000 for each investor to put 100K in, or each investor doesn't have 100K, sure, you could possibly characterize one as an essential employee, and you don't have to each put in 100K. Again, there's nuances you'd have to work through with us, but it opens new opportunities, I think, for
Cool.
people.
Right on. Well, that
Well,
was very informative. That was very interesting.
yeah, yeah. I mean, maybe some other, other things that have come up recently, maybe in closing, just kind of some various questions that people ask about E2, and I'm sure you talk with people about this regularly, Alex, some people wonder whether uh, you should, where to best register your company, right? When you're coming to the US for business. And, Wyoming, Delaware, Nevada, in some cases, those are always well-known jurisdictions outside the US. Everybody always says, oh, you got to open a Delaware LLC or a Delaware C Corp or something. Um, it really depends on your situation, but I don't think in a lot of cases it matters too much. And I think in most cases with our clients, at least for the majority of them, it's just easier if you open the company in the state where you're going to have the office. Because even if you open a Delaware LLC, and very few people actually have a business in Delaware, right? Because it's such a small state, and you open it in Delaware, but your office and your business is in Texas, you're still going to have to register that Delaware LLC in Texas. You're still going to have to pay taxes in Texas as if you were a Texas company. You're going to have to pay annual fees in two states, both Texas and Delaware in that case. So I'm not always sure it's worth having, those extra headaches. And it's something that we discussed earlier, Alex, as well, is there could be some cases where you'd prefer a Wyoming LLC, maybe for confidentiality purposes, because some states are much more rigorous in terms of disclosing shareholders or protecting shareholders and stuff like that. So that might be a reason you might say, hey, in Wyoming, they're going to protect, they're not going to disclose the owners ever, under any circumstances. And that's worth it to you. Then yeah, maybe it's worth registering your company in that state as opposed to where you're going to operate.
Amazing.
Yeah. And I think related to that too, sometimes people ask, do you have to live in the state where you have your operations? And the answer to that is no as well, right? You don't necessarily have to live. You have to be able to show that you're going to manage it, but especially depending on the type of business you have, so many businesses these days can easily be managed remotely, or you could say you're going to travel regularly to that state. So that's another, item that gives flexibility to people as well. Any other recent questions or comments, Alex, that maybe we should address before or no?
Honestly, I think so far those are the most interesting ones, but we could definitely discuss further on later
Sure.
episodes. That's for sure.
Absolutely. This is far from our last episode. So hopefully this was a benefit to everybody, and hopefully this latest edition of our all things related to E2 was of benefit to you. And if you've got any questions about a potential E2 structure you're looking at, or you're even further along in the process and you're ready to get started, please reach out to us. Alex will, give you initial overview, how we work with clients, what we do, what our terms are, stuff like that. If you think you might need a consultation with our E2 team, we can certainly set that up as well, or we can just get started right away off the bat. Thanks
Yeah,
again,
if
Alex, for your
you're
time. Yeah, go ahead.
yeah, no problem. I just want to say if you're watching this video, most likely the links are in the description below to book a call with myself or with AmLaw Group. So feel free to look into those links and schedule your call with us today.
Absolutely. Thanks for mentioning that. Until next time, thanks again, everybody. Thanks, Alex, and we'll see you around.
Thanks, Charles.
Thank you.
Cheers.